Welcome to Lesson 8, the final lesson in our Basics of Immigration Law course. In this lesson, we'll review and summarize the key topics covered throughout the course. From the foundational sources of immigration law to the different types of visas, the adjustment of status process, waiver options, and the government agencies involved, this summary will help reinforce your understanding and connect the concepts you've learned. Let's take a look back at what you have learned. This course started with the sources of immigration law. The sources of the law are the U.S. Constitution, the Immigration and Nationality Act, the Code of Federal Regulations, the Foreign Affairs Manual, USCIS Policy Manual, Executive Orders, Attorney General, and BIA precedent decisions. I encourage you to read and get familiar with the sources of the law. This will help you understand the legal foundations that shape immigration policy and decision-making. You learned about the ESTA visa waiver program, which allows nationals of participating countries to visit the U.S. for tourism or business without a visa for up to 90 days. You learned about non-immigrant visas like the B1/B2 tourist and business visas and the F1 student visa. You learned to complete the DS-160 form, what to expect at the consular interview, and how to apply for a change of status or to extend the status using Form I-539 within the U.S. if needed. Most importantly, we emphasize the need to maintain lawful status at all times to avoid serious immigration consequences. We then examined the journey to lawful permanent residence, starting from the petition, whether family-based or employment-based, moving to consular processing using Form DS-260, and finally attending an interview at the U.S. Embassy or consulate abroad. You learned the importance of the I-94 arrival or departure record, a key document that confirms when and how a traveler entered the U.S. and how long they're permitted to stay. For those already in the U.S. who entered lawfully, we introduced the concept of adjustment of status. This is the process of applying for a green card without leaving the U.S. Here are a few key points. To be eligible for an immigrant category, they must have entered the U.S. with inspection and admission or parole. The form used is Form 1485, and supporting documents include proof of entry, identity, and eligibility. Adjustment of status applicants can also apply for a temporary work permit and advance parole to travel internationally while the application is pending. You also learned about waiver options for individuals who entered the U.S. without inspection or overstayed their visa. Overstaying can lead to bars on reentry of 3 or 10 years, depending on the length of the unlawful presence in the U.S. In certain cases, a waiver such as Form 601 or I-601A may be available if the applicant has a qualifying family member who would suffer extreme hardship. Lastly, we identified the key government agencies involved in immigration enforcement and processing like USCIS, CBP, ICE, and the Department of State. Each agency plays a distinct role in adjudicating applications, protecting borders, and managing visas. That wraps up this summary lesson. Thanks for watching.